So you have to assert yourselves with your SIs to establish your expectations of how AI is to be configured and deployed, and make sure that they're aware of the configurations needed.
Welcome to Insights for IT Negotiations, a podcast by UpperEdge, a leading IT sourcing, negotiation, and project execution advisory firm. I'm John Belden, UpperEdge's Chief Research and Strategy Officer.
And I'm Kylie Chisholm, UpperEdge's Marketing Manager. Join us every other week as we share insights to help you maximize the value of your key IT relationships. In each episode, we'll delve into the topics that matter most to IT decision makers and sourcing professionals. Hello, everyone, and welcome back to another episode of the Insights for IT Negotiations podcast. I'm joined today by my co-host, John. John, how are you doing today?
Good morning, Kylie. I'm doing just great. Thank you.
That's good to hear. We are also joined by a very special guest. We're joined by Sarah Alt, who is the Chief Process and AI Officer at Michael Best and Friedrich LLP. And she's here to talk with John a little bit about AI ethics, AI legislation, really get into the meat on how AI is affecting our nation and how it will have that trickle-down effect on our customers. So Sarah, thank you so much for joining us.
Great to be here. Thank you.
So, hey, Sarah, we've known each other for a while, but can you just provide, as a starting point here, a little bit about your background, where you started, how you came through industry, how you got into AI, et cetera, as a foundation?
Yeah, sounds good. Thank you. So I am a career technologist. Although I work for a law firm, I'm not an attorney of the firm. So I should make sure to, call that out right here at the beginning. But as a career technologist, I've been through all of our major, either disruptions or opportunities of technology in the last 25 years, almost entirely as a buyer or subscriber of technology. So I can really relate to this audience very well. Although during my consulting days, I did work on teams that implemented some of the biggest of these technologies, like your Oracles, SAPs, and Googles. So I have sort of that multifaceted perspective. And then, of course, now working for a law firm. So I'm the Chief Process and AI Officer for Michael Best. We are a U.S. national corporate law firm with over 350 attorneys in 19 offices in 10 states in the U.S. So today my role is sort of a dual role for the firm. I'm primarily accountable for our technology investment portfolio to activate our professionals and their technology needs to serve their clients best. But then also my AI expertise is available to clients as they're navigating their technology journeys as well. So I have this great opportunity to both work, within the firm and activating our professionals, but then also working alongside our attorneys to guide our clients.
So today you can live up to the you're not a lawyer, but you play one on TV, if we say this for
That's right. Nothing should be construed as legal advice from anything that I'm saying. That is the official statement, right?
Yeah, that is a similar position that UpperEdge is in quite often, right? We're not attorneys, but we provide advice in that space. One of the reasons I reached out to you is because you had posted that you had done a lot of interesting work with the state legislature in Wisconsin, and I thought it would be interesting for our listeners just to understand, a little bit about that work, what you were doing in that work, and maybe some of the big interesting findings that came out of that.
Yeah, thank you, John. Before I give you sort of that background, I will say that it certainly was a career-defining moment for me. So I encourage anybody who's given that opportunity, who is granted that opportunity, to take it as you can and as it fits, with either your expertise or the opportunities that are presented. Because to be able to understand and give a perspective as a technologist to a legislators or a legislature is truly valuable, especially right now when everybody's trying to figure out artificial intelligence and the technology disruption and opportunities. So the intent and the scope of this study and of this study committee was to determine if or to what extent we would legislate or regulate AI in the state of Wisconsin. And I'm careful to say if or to what extent, because each state will approach legislature study committees like this differently. If they're already intending to legislate and regulate, that study committee may actually have the responsibility of putting those recommendations in place with the assumption that a law would be put on the books. But our state Senator Bradley's vision was to assemble a cross-disciplinary study committee that would consider this, visit various locations in the state, invite witness testimony from experts and practitioners in higher education, healthcare, law enforcement, manufacturing, and even government to understand both the opportunities and the challenges, very relevant testimony to help us understand the opportunities and challenges in each of those sectors in Wisconsin. And the objective, like I said, was not necessarily to architect a bill, although some study committees will get there. Senator Bradley was very clear that it is a fine accomplishment as a committee to at least make recommendations to the legislators as they resume sessions that would have resumed very recently, especially considering that this was an election year and that we have a new presidential administration. That all had to be factored into the timing and, of course, to the domain of talking about artificial intelligence.
So what were some of the big findings that came out of the study itself?
Yeah, so if I summarize our recommendations, a majority of us agreed that even if we don't legislate AI, the state of Wisconsin should probably still pursue prior data privacy legislation that was previously stalled. So a majority of us recommended that we at least dust off those, the data privacy types of bills. We unanimously agreed that Wisconsin should not pursue comprehensive AI legislation and instead pursue niche or targeted legislation for areas of high risk and make this a risk-based opportunity. Make sure that we're targeting where there's a high risk to exploitation or abuse of the technology instead of going very broad with this legislation. One of those niche areas, actually, John, that was very interesting that we again unanimously agreed with is that the legislature should consider AI detection that would assist with public safety. Again, all appropriate versions of this, but think of AI-powered gun detection in schools and universities and on campuses. And could the state of Wisconsin, legislate that and require that in the name again of public safety? Another one is that we unanimously agreed that existing laws should apply to AI and to avoid duplicative statutes that maybe unnecessarily call out AI. And I know that kind of sounds sort of like, kind of foundational, but I think sometimes we have to also consider that, we've already had a lot of laws on the books. And we just are still trying to figure out what the gap is that AI presents itself. And then do we just narrowly look to legislate for the gap instead of doing something more broad or redundant?
So what would be an example of the existing laws would apply to AI in something that might be relevant to the corporate audience that we're dealing with?
Yeah, so like the examples that we always use sort of with our public audiences is that okay, so for now, we still have, anti-discrimination and anti-bias laws on the books.
Okay.
So, you can't intentionally discriminate against, certain protected classes. Actually, I'm very careful with that word intentionally because we're also seeing some courts are saying that intent is not necessarily the measure. Now, if you had reasonable business knowledge of, say, a product or a service, if it was reasonable to assume or reasonable that you should have taken greater care in how it was used, intent is no longer the bar, right? So you have
Right.
to think about just in terms of, is it commercially reasonable to assume that could have been discriminatory, even if intent was not the bar. Product safety laws, right? So like you can't have products or goods that intentionally harm humans or that are not quality. So if you think about those kinds of already statutes and governance and regulatory frameworks that we have in place, they still should apply. Again, like our study committee recommended, is that AI does not suddenly just make those laws not applicable because it's a technology instead of a human or a company or a business to be held accountable.
So on the point of discrimination, if I can just bring one of the lawsuits that I recall reading about, there was some lawsuit that was brought up against, I think it was against Workday,
Yeah.
On discrimination,
Right.
and in that lawsuit, it implied that the AI that was behind Workday was discriminatory toward, I think, a particular individual in terms of evaluation of their application.
Right.
Now that I know that, right now that I know that as an external client, that these products may have discriminatory tendencies,
Mhm.
am I now obligated from that sense of doing my own due diligence on this
Yeah.
to say, because it's a known finding out there, right, that they could be like this, I have an obligation now to ask questions with regards to how that LLM, perhaps that's sitting in the background, was constructed.
Yeah, John, that Workday lawsuit is actually one of the again relevant, current, still active lawsuit examples that we use because first we're talking about a high risk use case of AI. Anytime we're using AI in an employment context, again, for as long as we have the laws that we do in place for anti-discrimination and bias and other civil liberties, like that falls squarely in there, and a Workday or others like Workday certainly are playing in that space and providing technology in that space. So Workday initially attempted to have that entire case dismissed on the premise that we're just the technology provider. So we're not. Workday argued that the company that subscribes to its Workday technology, which I know our UpperEdge community is more the subscribers and the buyers, right?
Right.
So Workday argued that that it was the subscriber that is responsible for making the decisions that resulted from using that technology. Now that particular court did not allow that case to be entirely dismissed from Workday's accountability, but did also signal that Workday is not solely accountable. So back to your point, John, this whole idea of, and I think a couple of things we're going to start, see change even with the new Trump administration is a little bit more of that shifting to buyers and subscribers in the name of trying to make sure that we are not stifling innovation and that we're not stifling the Workdays as an example from doing really awesome stuff with artificial intelligence in their tools and shifting some of that accountability to the buyers and subscribers to remind us that it's our data, it's our processes, and it's our
Right.
people that are being applied and used with those technologies. And so that line of accountability is not quite as one-sided as even we first thought in the first, call it 6 to 12 months of generative AI.
Right. Right. And I think, one of the things that brings up then is, as companies begin to pursue solutions, right,
Mhm.
or software packages that have embedded AI,
Mhm.
that you could extrapolate even further now and get into the systems integration space and say, you've got to make sure that the methodologies that they are bringing to the table, right, incorporate appropriate due diligence associated with the purchase of those software packages, right, to make sure that they're covering those bases with a methodology that's going to give you confidence that you're ultimately going to be compliant.
Yeah, and John, this is, not just a shameless plug for legal services, but I will tell you that because there is no single standard, systems integrators are going to rely on the organization to set the guidelines, principles, and governance in place. Again, you would hope that, of course, an SI is not going to intend to break the law. They're not going to misguide you into breaking the law. But again, they should not be your sole representation of what is the law, the interpretation of the law, how you're configuring. Forget about even law. The first step is don't break the law, right? We would obviously want to advise there. But the second sort of lens that we need to look at this is, once you pass the test that you're not breaking the law, every sector and every organization also has its own, risk their own risk profile associated with everything else and how the data is used and how the data is collected. And that requires that you're articulating that for your systems integrators because they're not solely accountable for that. So you have to assert yourselves with your SIs to establish your expectations of how AI
Right.
is to be configured and deployed and make sure that they're aware of the configurations needed also for use in countries with more stringent AI laws. So that's the other thing, especially I know you have a lot of global companies, right? Global clients. And so it's one thing to say that the US has, sort of this patchwork quilt and still trying to figure out AI laws. But there are other countries that do have them on the books and already activated and enacted in some cases. So there's always that dialogue to make sure that we understand the configurations that are needed elsewhere too.
Yeah, I think, and maybe what you're referring to, at least from my perspective, there's a lot. There's the European Union has been doing a lot of kind of issuing of, and I don't even know what the right word is. I don't know if it's regulations or it's standards, but certainly it is stronger, at least from my perspective, over in Europe than it is in the U.S. right now in terms of um, private companies' obligations to live up to certain standards.
Yeah, for sure. I mean, it is truly the law. It is considered the EU AI Act is a law. It's a very comprehensive law. It's very much akin to the GDPR standard that we knew of, 2016 to 18, and so it is, and parts of it are already enacted and in effect. And now it goes in phases, just like GDPR did. So I think we're about 6 months in. So the first, enforcement began, and then there will be another 12-month, sort of milestone where other parts of the law go into effect, and then finally at 24 months. So it still will take some time, but it is definitely the law. And alongside that is therefore then the recommendations of and the frameworks associated with then how do you ensure that your, again, people, process, and data are all in compliant with that, and depending upon, again, the governance that you need in order to do that. So yeah, the EU is definitely probably the most comprehensive and most significant here.
Yeah, and they've always been, at least from my perspective, in the, let's call it the lead, especially when it's related to personal data privacy, and the
Indeed.
individual privacy laws associated with that.
Indeed. And I would say that, sort of taking a page from that sort of core of who the EU is, again, values, culture, and, again, the historical, whether you call GDPR, whether you believe that to be a success or otherwise, it would definitely was, significant in terms of also what it, what it led to here in the States, right? So, shortly after that, we saw California's CCPA, and now we have at least 20 states with data privacy laws. But back to the EU, I think also sort of, again, if you really want to geek out and study it, you look into that EU AI Act, and you will find that it sort of is a yes and building on the foundation of more of a risk-based approach. So,
Right.
Actually banning, the use of artificial intelligence in certain cases, and then those that are considered high risk carry
Right.
a more stringent requirement. And then there's, those that are not necessarily categorized as high risk. So it's also a risk-based standard, which is something, that a framework that I think, many jurisdictions can learn from as well.
So let's pivot and come back to the U.S. now,
Yeah.
right? One of the things that we've seen is there was the Biden administration issued a kind of a comprehensive, I'll call it, set of AI guidelines. The Trump administration has issued, something to that respect in terms of, I'll call it, making adjustments. I mean, what's the whole your perspective on where we are, legislatively at a national level?
Yeah, so I think our audience should be reminded that the first Trump administration actually set the first executive orders in place for artificial intelligence, including signaling trustworthiness and responsibility. The Biden administration left those executive orders in place and built upon them by sort of, again, doing a yes and to that, saying, okay, we actually are good with the foundation that the first Trump administration put in place, and we're going to sort of amp that up and level that up. And remember, that was at a time also when, we were seeing a lot of activity, especially in understanding the impact of social media and all the data that we were targeting and that we were taking, and getting and understanding about our citizens. So, that was at an administrative time when, we were really looking at those technologies. And then, so with this most recent executive order from the second Trump administration, we're definitely getting a signal of the intentions to make this more about innovation and leadership, and the U.S. leading in innovation. The administration has signaled its intentions, as an example, to make federal land available for data centers. We've seen movement to govern chip distribution, to maintain a leadership position there and more. Meanwhile, there's a lot of confusion, though, about interpreting, the existing anti-discrimination laws and discrimination and bias that we talked about earlier, and if those are still considered a high-risk consequence of using AI in talent management, for example. So, right or wrong, there is a viewpoint that trustworthiness and responsibility stifles innovation. And I believe this administration will kind of leave trustworthiness and responsibility to the private sector, sort of self-guide and self-standardize. The good news is that, we do have standards bodies out there that were very contemporary and current. They didn't fall behind per se. And they have issued some very good frameworks that, even if they're not necessarily, required by the federal government, certainly we have some guidance out there that if we had to self-guide and self-standardize, we could.
Did you know that UpperEdge offers subscription advisory services? This on-demand solution provides essential benchmarks and market insights specific to your business needs precisely when you need it, empowering you and your team to make informed decisions for your IT initiatives. Position your team for success. Reach out today via the link in the show notes to learn more.
Yeah, and I think the European standards, to a certain extent, for any of the vendors that are going to want to be global players, they know they're going to have to jump over the hurdles associated with the European standards. Why would you develop two different products, one for the US and one for Europe? Just from a straight up product development standpoint, it makes sense to say, I'm going to develop my product in order to be able to be compliant in the broadest range of countries.
Yeah, and this, John, you're absolutely right. And I think this is where sort of the values and altruism of companies, and where we're really going to see sort of, I liken this to, social responsibility and those kinds of goals and aspirations that organizations had, right? And that, responsible and trustworthy artificial intelligence, if it's not going to be legislated, then who you are as an organization, whether you're, again, a builder, developer, deployer, if you're a buyer, subscriber, is somewhat going to be, measured by your position on what you're doing, above and beyond the law. So whether you're offering, to your point, John, if you're choosing to offer a completely separate product that is compliant for the EU than the US, or if you're setting your bar to basically say, look, the highest standard based upon, our belief in that system is the EU, and therefore, we're not going to produce another product, or we're at least going to offer configurations of an existing product. That certainly is sort of a middle ground hybrid approach, right? Where it's a single product, but there are, configurations, or there are, radio buttons of things that we turn on or off for that situation.
I really love your take on the idea that it's an opportunity for companies to actually differentiate themselves in, right? That says, we're not leaving, we're not coming in here with something that's minimally compliant. We're coming in here with, this is our approach and this is our values. And so therefore our values become part of the product that we're selling to you.
Yeah, I mean, we are seeing situations where and truly this is coming from first from companies that are global companies, right? That know that they have higher responsibility towards that to citizens in other countries. But I am seeing, and we're having conversations even with some of our largest clients about the competitive differentiation that is still here. By saying, again, it's funny because in some of my public audiences, my public talks, John, I will lead with, how trustworthy of a company do you want to be? And It's funny because everybody looks at me and goes, well, of course we want to be trustworthy. Okay, so what is it worth to you to go above and beyond, though, what the law says, right? So if the law of the land, whatever land that is, says this is as far as you need to go, and again, it's no big secret. Y'all can understand my background, that my background is in, the ethics and responsibility. So I'm not shy about the fact that I still believe that there is, an opportunity and a competitive differentiator here to figure out in your sector and in your target market, what does the, again, going above and beyond the law, or helping your clients to be successful. Because if you're a competitive differentiator for them, again, proportionately speaking, John, we know there are far more buyers and subscribers of technologies than there are developers. And so we're seeing a lot more global companies that are wanting to establish, AI use standards, either internally or in how they're also developing AI for products and services, that meet the most stringent laws and that go above and beyond because they just want to do the right thing.
Exactly. So I would be remiss if I didn't bring up the subject of DeepSeek. And what's been in the news for I'll call it now, when this is going to come up, for the past few weeks. To me, this is somewhat of a, I'll call it, is it a game changer? Is it not a game changer? Right? Did they truly develop it at the cost that they actually developed it? And if they did, right, what do we know about behind what was actually in the LLMs?
Mm-hmm.
And as we think about the development of those LLMs, how does it change your perspective or what your thinking is?
Yeah, I'm glad we're unpacking this, John, because again, super relevant, timely. That's exactly what I know your listeners and subscribers want to hear. So, I mean, the DeepSeek release certainly is intriguing. If we just look at it through a regulatory lens first, I think the Trump administration will at least need to assess the national security risk and learn from our experience with ByteDance and TikTok to do this swiftly, not 8 years later. Just given how significant it is and the accessibility of it, right? So that's the first thing, kind of hurdle that we just need to make sure that we're passing. Second, I expect that again, the administration and others will discuss what this means for maintaining leadership and innovation, because again, those are the signals that at the federal level are most important: national security and leadership and innovation. So if the administration believes there's a threat to either of those, national security or leadership position, again, this is just crystal ball, my opinion, and from what I can see, I do think we could see some movement toward regulating or restricting it or figuring out, what does that mean? Alternatively, this model could have come from any nation that persisted, that with enough persistence to iterate on an existing idea or existing data, right? So, we could see it through the U.S. versus China assessment, but again, I don't think that's necessarily the whole story here. The DeepSeek move really could catalyze even more innovation to reimagine, model development and deployment altogether. As a technologist, I invite audiences to consider the significance of an open source model like DeepSeek versus the closed models or restricted models that preceded it. And what does this mean for innovation going forward? Again, like I said, not to dismiss the significance of or the importance of national security or anything else. We obviously have to, evaluate for that. But if again we get through that and we understand that, I think the bigger conversation here and the bigger opportunity is around just the significance of that technology being an open model and how we got there.
Yeah, and I think that's an excellent point. This is not a China thing. I mean, you could do your quick fix on China, right? And say, okay, we're not going to allow that to come out. But to your point, which I think is an excellent one, this could have came from anywhere. Right. So what's the repercussions of that, meaning that it came from anywhere? It could have came from the US. Right.
Yeah.
There's no reason why a small vendor in the US with enough horsepower right behind it, or a university, could have developed the same thing.
Right. And actually, you could argue that is exactly what we have been doing with the access that we did have to ChatGPT, even though it was a closed model, and you had to pay to be able to get to that level of integration. But that is, exactly what we were doing. We just weren't doing it the same way.
Right.
And we weren't launching it with the same intent. Right. So, yeah, I think it's the right, questions to be asking, and it's the right time to be looking at this. I don't think we should be surprised that somebody came, with whether you call it a cheaper model or less expensive model to do. I mean, that's economics, that's macroeconomics, that's product, supply and demand. I mean, this is all the things that a healthy market has, right? We just got to make sure that we understand if there are any unhealthy or risks, right? To make sure that we're mitigating and following, and then learn from this.
What really was interesting to me on the subject that we're talking about here, in terms of the legal components of it. If we look at it before and after for a second, before DeepSeek, right? The focus was on, let's call it, 5 to 10 big vendors in the United States that were going to be creating these LLMs because of the cost associated with it. And then it was, from that perspective, our obligation to look at those 10 big vendors and saying, are they doing it in a way that is, protective of all the rights and all the laws?
Mhm.
If the capability exists now to develop these comprehensive LLMs and it costs less than $10 million to do it, right? All of a sudden, that becomes something that any company can do for itself, right? Whether it be, it's not restricted to Microsoft, it's not restricted to Google. Any company will be able to do it. And if anybody can do it, right, then all of these rules associated with developing LLMs, now apply to all of those companies. And I'm not just looking to see if my vendors are compliant. I have to be compliant.
Yeah,
Right? Which is going to change the game dramatically.
absolutely. I heard a really great analogy, and obviously this stuff is all fresh, so everybody's trying to make sense of it, right? And sometimes analogies help, sometimes they're imperfect. But the one analogy that's running through my head that I think really helps lay people to understand is this concept of a master and an apprenticeship model, right? The master doesn't necessarily need to teach everything to the apprenticeship model, and an apprentice can be very good at what they do, by taking and observing and learning just enough, right? And so I think that's kind of where we're seeing this distributed opportunity and this decentralized opportunity, again, to sort of bring this to more of a workable level, bring those models to a more a more nimble, workable level. But John, you're absolutely right that then shifts the burden or shifts the responsibility, shifts accountability,
Right.
in ways that this begins to, and I'm not saying we're there yet, but it begins to sort of categorize this technology almost no differently than the existing technologies that we've had for decades.
Right,
Like
exactly.
we are just as responsible for what somebody does in our finance and accounting systems and accountable for those mistakes and for those and the cybersecurity and protection of
Right.
those, as we are in any of these models, if we do take them in house and if we do, the development there.
Yeah. So it is. It's a. I don't look at it. I guess I don't look at it as a negative thing
Right.
that they developed this, but it certainly is going to change the course of the direction of, I think, what people perceived was going to be the development path and the implementation path over the next 10 years. I think that's changed dramatically.
Yeah, agreed.
So I mean, just from a legislative point of view and the legal point of view, how are you seeing vendors and or systems integrators kind of respond to this? I mean, are they going to market with we are compliant, or what are you seeing in that space?
Yeah, so I think it's reasonable to assume, and again, this is my opinion, that technology developers and software providers will determine if they are benefiting from a more relaxed regulatory landscape, like we talked about earlier. Um, Perhaps one you could even categorize as more mature now too, because maybe we had some sort of knee-jerk reactions at the beginning, right? And so we've kind of seen this sort of play out. So you could see this both ways, that either that there's been maturity in understanding that, or that there's going to be the opportunity of a little bit more relaxed regulatory space. So I think we spent a little bit more time with generative AI in the wild, so to speak, and a regulatory landscape that resembles more traditional interpretations, like we talked about, of quality products that are fit for purpose, workmanship and quality measures, instead of those specifically around trustworthiness of AI, especially as long as they can make the case that, this is your data, this is your process, and your people using it. So, I still believe there will be good and trustworthy, responsible intentions by software providers, and that they will will drive their interpretation of going above and beyond. But again, this will still fall on the subscribers to sort of make it known what their intentions are and what they're looking for. If there was such a thing as like a favorite new clause that I'm seeing, John, in subscription agreements, because working for a law firm now, even as a buyer, my entire, career, I have a greater appreciation for clauses in subscription agreements. But the latest one that I noticed that a vendor offering, it was the first time I'd seen it, is allowing an agreement to be reasonably and in good faith amended as AI laws change. So I saw
Oh,
it for the
okay.
first time, like I said, but kudos to the vendors who are at least offering this in their boilerplate. It's nice to see. It's a recognition of, hey, we're all in this together. We're all trying to figure out what happens. And we're willing to offer you, again, reasonable and good faith amendment in the event, especially because I think, vendors and suppliers are recognizing that, it's tricky for a buyer right now or a subscriber to contemplate anything longer than a 12-month subscription on artificial intelligence. Where I'm, of course, talking about those that are new subscriptions and not necessarily, your Workdays or your SAPs or your Oracles that are
Right.
incorporating, artificial intelligence into existing. But again, it's kind of hard to imagine, like, what is this technology going to be like in my second year or my third year of a 3-year agreement? And so I think to the extent that vendors and suppliers can recognize that that is, sort of a natural concern that subscribers have, I think that's, dutiful on their part. The other one that I'm not really a big fan of that has happened recently is the automatic opting in of data for training the model. And I think that buyers and subscribers should be asserting themselves again, to the extent that they can and the extent that it is negotiable, to make sure that that is not an automatic opt-in, especially, again, in the case of high-risk information, right? Your trade secrets, your intellectual property, your employee data, your anything, where artificial intelligence is used in the talent management context, those high-risk areas, automatic opt-ins are just not very comfortable.
So you've kind of gone into the last area that I wanted to probe on, and that says if we're thinking about buy side now,
Yeah.
right? And if I said, Sarah, I'm a simple guy, right? Give me my 5 rules. Give me my 5 rules or my 3 rules that I've got to follow this checklist to get started when I'm thinking about buying AI, whether I'm buying it from a software vendor or I'm buying services from a systems integrator. What's Sarah Alt's? You got to do these 5 things.
Yeah, mine are actually 3. I mean, there's
All right.
probably 5, but but certainly, as a law firm, with our duty to the confidentiality and privilege of our clients, and that is, utmost importance, in providing counsel, and being in business, and practicing law. I would say that has put us in a very, critical standard of what this looks like, and so for sure. The 3 things that we ask now, we have an AI assessment process. We actually based ours on NIST, and we offer this model to our clients as well. There's 686 standards in the NIST risk management framework. That's not reasonable. That's not necessary for buyers and subscribers. So we've gone through that. We've culled through that and pulled out and lifted the most important of those. And I think we're down to about 55 attributes. And it's just a yes, no to make sure that we have it well documented, very similar to security, reviews, and making sure that, our vendors and suppliers are attesting to that. But the 3 that I make sure that we're always validating for sure is making sure that the data is not used to train the public model. It's not used to train a private model. Again, because our data is also our clients' data. So we have requirements from our clients to do that. And then the third item is to make sure that the data, again, in our case, is not commingled with other clients. And, I think that even though you may not have a ton of law firms on this, listening in on this, I think that with those being sort of the standard, there's a version of those that can be worded in such a way that that I think still protects, any business from making sure that there is an understanding of the extent to which data is used to train the model, if you really are consenting to that and want to give that away. And then, of course, like I said, the extent to which, you do or do not want your data commingled with everybody else's, whether it's for training or not. So those are definitely our 3 most important items that we look at.
Sarah, just to be clear, because when I went, I was picking up 2 of them, but I'm not sure I picked up the 3rd, right? So making sure that my data is not available for use of training, right? What would be the second one?
Yeah, so we actually split the training into two parts because we're very clear that it cannot be for the training the public model. We do not want it training the private model, meaning the vendor's own private model. And then the third one is making sure that it's not commingled.
Okay, all right.
So you could argue that training in general, usually when you do have a do not train, it's one clause. You don't see it split out between, most vendors won't split out the do not train clause into internal versus external. But sometimes it depends on the vendor. Sometimes they really value the ability to use your data to train even just their internal model. And so, I'm also not a fan of being silent on this. Just because it's not in those agreements doesn't necessarily mean that has been explicitly understood. So it's worth looking at and worth considering, again, in those situations where you are concerned about the risk of that data, and making sure that you understand their business model, the vendor's business model. And if that is important to them, you got to just understand how to negotiate through whether it is training for the public model or the private model.
Well, I'll tell you what, one of the things I've learned today, Sarah, is I won't argue with you on this point. Okay. so I won't make it, I will not make it a point to argue. I've learned a lot today, and I'm just going to go ahead and subscribe to the Sarah Alt 3 things, and we'll go with that. Wonderful. So Sarah, I really, really appreciate you taking the time that you took with us today. I think we've had an outstanding conversation. If people wanted to reach out to you at all, is there a way that they can get in contact with you? And I know that Kylie will put some things on the podcast to connect on there. But what would you suggest?
Yeah, definitely. Best way to reach to me directly is through my LinkedIn profile and reach out through LinkedIn. Also, I would direct you to our AI services website at michaelbest.com, where we also have a legislation tracker that is tracking over 170 AI bills and acts and laws all throughout the U.S. So there's another way to get connected with Michael Best services above and beyond just me.
Awesome. And like John said, we'll make sure to have those all linked in the show description. And I'll reiterate what John said. That was a really insightful conversation. And I also won't be arguing with you about anything. And I think it'll be a good one to reflect back on as the year goes on. Selfishly, I think John and I will have some really good conversations that sort of snowball off of this one. So we appreciate you joining us, and definitely subscribe to this podcast if you want to hear those updates. And yeah, thank you so much for listening. Thank you for listening to Insights for IT Negotiations. This episode was hosted by John Belden and Kylie Chisholm and produced by Mike Brown. Be sure to subscribe to the show wherever you listen to podcasts so you never miss a new episode. For more information on IT sourcing and risk management strategies, visit UpperEdge.com and subscribe to our monthly UpperEdge newsletter. Thank you for listening.